in labor, employment relations matters. 2. The claimant's salary. 2. A declaration that the continued refusal of the defendant to pay the claimant his December salary and Christmas bonus is illegal, unlawful, amounts to unfair labor practice and contrary to international best practices in labor, employment, and industrial relations. 3. An order compelling the defendant to pay the claimant the outstanding sum of 99,746 naira 44 kobo, being the claimant's outstanding salary for the month of September 2021. 4. An order compelling the defendant to pay the claimant the outstanding sum of 99,746 naira 44 kobo, being the claimant's outstanding salary for the month of October 2021. 5. An order compelling the defendant to pay the claimant the outstanding sum of 99,746 naira 44 kobo, being the claimant's outstanding salary for the month of November 2021. An order compelling the defendant to pay the claimant the sum of 207.380.94 kobo, being the claimant's salary for the month of December 2021. An order compelling the defendant to pay the claimant the sum of 51,480 naira, being the claimant's Christmas bonus for the year 2021. And an order compelling the defendant to pay the claimant the sum of 414.761.88 kobo for breach of the employment contract, being 2 months' salary in lieu of termination by the defendant. An order compelling the defendant to pay the claimant the sum of 224.250, being his annual stabilization fund for the year 2021. An order compelling the defendant to pay the claimant the sum of 180,800 naira only, being the claimant's leave allowance for the year 2022 and 2021 respectively. An order compelling the defendant to remit the claimant's pension in the sum of 170,600 naira only for the years 2020 and 2021 to the claimant's pension managers. An order awarding the sum of 20 million naira against the defendant as exemplary damages for the illegal and unlawful refusal of the defendant to pay the claimant his entitlement. Interest on the judgment sum at the rate of 22% before judgment and 15% post-judgment until the judgment sum is liquidated. A perpetual injunction restraining the defendant or any of its officers from constituting any disciplinary panel from going ahead to determine the claimant's case. And lastly, for the cost of this action. The claimant's case. The claimant was an employee of the defendant for a period of over 2 years as head business development. He was responsible for marketing, recommending suitable customers in need of loan facilities to the defendant. That every loan application goes through the credit committee for deliberation and approval through the risk assessment committee, and he was not a member of both committees nor involved in disbursement or recovery of the loan facilities to any customer. That KYC was conducted both by claimant and defendant on all her customers before approval and disbursement of funds. That he was never in charge of approval of disbursement of funds, neither did he provide fictitious address or incomplete documentation whatsoever for disbursement of loan that the defendant has, and that the defendant has not incurred any loss of 9 million naira. Neither did he abscond from work. The defendant unilaterally withheld half of his monthly salary and other allowances, which made it practically impossible to transport himself to work. And upon demand for the claimed sums from the defendant promptly sent a letter inviting the claimant to appear before a disciplinary committee. That he never had any oral agreement with the defendant to recover debts or receive half salary if he is unable to recover debts. The defendant has a debt recovery team, and he is not a debt recovery agent. He was confirmed on the 27th of July 2020 and was dutiful. His monthly salary was reviewed upwards to 207,380 naira 94 kobo. that the defendants withheld the claimant's stabilization fund in the sum of 224,000 naira, his leave allowance for the year 2020 and 2021 in the sum of 108,000 naira, pension fund for the pension remittance for the years 2021 and 2020 and 2021 in the sum of 170,600 naira, and half salary for the month of September to November 2021. Full salary for the month of December 2021, Christmas bonus as well, and 2 months salary in lieu of notice, 2 months salary payment in lieu of termination in the sum of 411.761.88 kobo. Due to the outstanding sums owed, he could not transport himself to work, only managed to resume work with the defendant on the 4th and the 5th of December 2022. That the disciplinary panel was set up to summarily dismiss him because his lawyer wrote to demand for his claims. It is therefore not true that the defendant could not be reached. To avoid payment of 2 months salary in lieu of notice of termination, which is one of the claimants' relief, the defendant had a tactic of not paying salaries. That based on the threat of arrest from creditors, he had to contact his counsel to help recover his entitlements. After the pre-action notice demand was rejected, it was delivered by email to the defendant's email address at info@mexcredit.com. The claimant tendered 8 numbered documents as exhibits. They were admitted and marked as exhibits C1 to C8. The defendant's case. The defendant's case is that indeed the claimant was employed as business development manager. He did not discharge his responsibilities to the satisfaction of the defendant. That the claimant conducted KYC assessment and reports on customers and deceitfully introduced customers whose loans are now in default to the defendant as reputable persons / business entities capable of taking loan facilities. That approval for loans was based on the KYC assessment provided by the claimant and was the singular most important requirement used in assessing the eligibility of an individual or business enterprise to obtain loan facilities from the defendant. The individual / business with deceitful KYC reports and in default of their loan repayment obligations to the defendant are as follows. It's all embedded, number 1 to 10, all embedded in the body of the judgment. The claimant also lost over 9 million naira in risk assets created, managed, and in the custody of the claimant without any serious effort at recovering these loan facilities advanced before he absconded from his duties since January 2022. By email of 27 August 2021, the claimant stated plans to recover the outstanding loans sums, but it was unacceptable to the defendant. His report was a disappointment, and based on the oral agreement with defendant, he was placed on half salary until the outstanding sum were fully recovered. The mail of 28 September 2021 was a mere formal documentation of what the claimant had been informed about beforehand. That the disciplinary committee was a fact-finding panel to consider the challenges in his recovery efforts and provide solutions to assist his efforts. That the claimant breached the contract by absconding, and since the employer has the right to investigate the activities and conduct of the claimant as long as that employment relationship subsists, it was therefore necessary as an employee to appear before this disciplinary committee to explain the position of affairs regarding the recovery rather than absconding from work and instituting this action during the subsistence of the contract. Under cross-examination, the claimant stated that without the KYC, it is impossible to process a loan application, thereby admitting that the KYC was one of the loan application process. In Exhibit C5, he acknowledged he had outlined, and I quote, the status of the recovery efforts he made on the non-performing loans that were placed, end of quotation. That he was not a loan recovery officer for the defendant. He did not apply for leave when due, thereby forfeiting such leave by implication. That being part of the defendant's stabilization fund was not compulsory, but he contributed to the fund as his salary was deducted at source. He never appeared before the state panel, which was set up to unlawfully dismiss him, and that he did not accompany counsel to the defendant's office to serve the letter of demand. That the defendant never told him to stop coming to work, nor terminated his employment before he stopped going to work. Regarding the unpaid December 2021 salary, he does not know other employees who were not paid, and he never wrote to find out why he was not paid. He merely assumed that the defendant did not pay him as a form of sanction. In the body of the letter, we have the defendant's final written address, the claimant's final written address. I'll go straight to the body of the judgment.
As the court pleases.
Okay, the court decision. The claimant is before this court seeking two declarations. A declaration that the continued refusal of the defendant to pay the claimant the outstanding balance of the claimant's half salary from the month of September, October, and November is illegal, unlawful, amounts to unfair labor practice, and contrary to international best practices in labor, employment, and international relations matters. Secondly, a declaration that the continued refusal of the defendant to pay the claimant his December salary and Christmas bonus is illegal, unlawful, amounts to unfair labor practice, and contrary to international best practices in labor, employment, and industrial relation matters. The issue for determination, as stated above, is whether, considering the totality of the evidence adduced by the claimant, he has proved that he is entitled to the declarations. The state of the law remains right that it is for him who asserts to prove the assertion by adducing credible, cogent, and admissible evidence in support. Sections 131 and 132 of the Evidence Act provides to that effect. A plethora of judicial decisions from the appellate courts, for instance, Dasuki versus FRN, Abdullahi Ogbere versus Adamupo, citations all provided are in support of this statutory provision. The proof required may be oral or documentary or even both. In a long line of judicial authorities, like Anifo Woshe versus Wema Bank, Anzewu versus National State House of Assembly, the appellate courts have held that a servant who complains that he is entitled to employment rights must found his claim on the contract of service and show in what manner the wrong was done. He must plead and prove the contract of service, which is the bedrock of his case. It is not the duty of the employer as defendant to prove, say Amodu versus Amode, Kato versus Central Bank of Nigeria, citations all provided. Thus, the claimant in the instant case is under an obligation to produce his contract of service comprising the terms and conditions of his employment. Once that is done, the claimant is expected to thereafter draw the attention of the court to how he is entitled to the claim sought. The claimant, in his attempt at proving his case, tendered 8 exhibits, marked as Exhibit C1 to Exhibit C8. Parties are in agreement that Mr. A. Odurudola was employed on the 12th of September 2019 and was confirmed on the 27th of July 2020. The claimant, in proof of this, tendered Exhibits C1 and C2. To prove he is entitled to a declaration that the refusal to pay him outstanding balance of half salary from the month of September, October, and November was illegal and unlawful, he gave evidence at paragraph 5 of his witness statement of oath that by his job description, he was responsible for marketing and looking out for suitable customers in need of loan facilities for due diligence and approval. In the course of his duties, he received an email on September the 21st, in September 2021, that management had unilaterally resolved to place him on half salary from September until all outstanding sums are fully recovered. See paragraph 14 and 15 of the witness statement on oath, Exhibit C5. The claimant testified during trial that he knew the 10 defaulters and conducted KYC, which involves visit to address for verification, provision of collateral, guarantors, and a credit check background, and management gives approval. As head of business development, claimant testified that his position did not impose an obligation to recover facilities. Therefore, he could not be placed on half salary by management. This court knows that in paragraph 5 of Exhibit C1, the offer letter reads, and I quote, "Please note that while in the employment of the company, you shall be bound by the conditions of service of the company as contained in the employee/staff policy handbook." The claimant did not tender his handbook to the court to enable the court to look at the expanded terms of employment as provided therein. Be that as it may, the court shall restrict itself to the contents of the offer letter. Parties are in agreement that claimant worked for the months of September, October, and November. The question before the court is whether the defendant company can withhold the claimant's half salary. Claimant during trial acknowledged he knew the defaulters and by Exhibit C5 gave a status report on their indebtedness. Claimant also averred that he is not a loan recovery agent and in fact a recovery department exists in the company and KYC was conducted by him and the credit committee and every application goes through a credit committee for deliberation and decision, then goes to the risk assessment committee to determine viability or otherwise of the loan. He was neither a member of the credit committee, risk assessment committee, nor involved in disbursement. See paragraph 6 and 7 of its witness statement on oath. The defendant in their defense stated that it was the claimant who introduced the 10 defaulters with an outstanding debt of 9 million naira. He conducted KYC, which was a key requirement to obtain loans, and provided fictitious addresses, some of who are currently at large. Furthermore, the proposed plan of action in email of 27 April 2021 to recover the debt was unacceptable. And on 30 August, claimant gave a feedback same day that he had given debtors 2 weeks grace to pay up. In the month of September, claimant was asked for a report on status of recovery, and same day, 27 September, he responded with an action plan, which the defendant considered disappointing, and he was placed on half salary, Exhibit D6. Therefore, the defendant's reason for paying the half salary is, and I quote, "until sums are fully recovered," end of quotation. By an evaluation of the evidence led, the court notes that the defendant company had a structured procedure to approve loans to customers. See paragraph 5, 6, 7 of DW1's witness statement on oath. There was a KYC stage. A committee was in place to approve disbursement based on KYC assessment. Other criteria involved were collateral, guarantors, and credit checks and boils down to approval by management. The existence of a debt recovery department in charge of recovery of debt, this court is convinced that the defendant was well structured with a check and balance procedure in place, or presumably so. The claimant was requested to give a status report of the 10 entities he introduced and was later placed on half salary until all sums were paid. This decision was management decision and was not a mutual decision. Defendant has argued that they have a right to discipline their employee and the court cannot interfere with that right. There is an implied duty in employment relationship that empowers the employer to exercise some form of disciplinary authority over the employee in cases of misconduct or to enforce compliance with terms of the contract of employment. See Imonike versus Union Bank. Citation provided. Where a disciplinary procedure is incorporated into a contract of employment, failure to follow that procedure may constitute a breach of the contract by the employer. See Post Office versus Strange. Citation provided. In the instance case, the defendant applied a disciplinary procedure unknown to the contract of employment to withhold half of the salary of the employee where there is a case of default by individuals or entities that are indebted to it. Courts are enjoined to ensure that any right claimed by parties in an employment contract are within the terms of agreement, which is binding on the parties. The offer letter Exhibit C1 provides for the salary, medicals, annual vacation, monthly turnover target, quarterly performance bonus, taxation, deductions, levies under the laws of the Federal Republic of Nigeria, line of reporting, probation, termination, notice, salary in lieu, benefits such as annual leave, annual increment and promotion referrals, transfers, and pre-disclosed inherited loans to other parties. The confirmation stated that all conditions of service remain the same as contained in Exhibit C1 and the employee/staff policy handbook. DW1 has argued that the deprivation of salary was only a challenge to action to recover the non-performing loan from entities recommended by the claimant. It was not malicious or unfair. Learned Defense Counsel is justifying this action by arguing that the only submission of the claimant is that there was no such oral agreement to pay his half salary until the non-performing loans were fully recovered. The defendant has also argued that prior to being issued Exhibit C6, the defendant had oral engagement with the claimant that he will be placed on half salary pending the recovery of the loan. By Section 7 sub 2A and B of the Labour Act, it provides that if there is a change in the terms of the written particulars of employment, the employee should be informed not more than 1 month after the change. The court observed that the defendant carried out this act for 3 months as confirmed in Exhibit C6. Sections 5, sub 1 and 15 of the Labour Act also prohibits an employer from making deductions or entering agreements with workers to deduct wages paid in respect of fines. During trial, it was evident to the court that the defendant company had structures in place for debt recovery, and claimant was not a member of the debt recovery committee. GW1 also confirmed claimant was not involved in loan disbursement, and the customers had guarantors even though there were no collaterals. More worrisome is his testimony that he had no evidence to show the debtors who are at large, and he had no evidence to substantiate the 9 million naira loss. This court has been able to deduce that the terms of the contract did not justify the procedure for the disciplinary action to put claimant on half salary and to withhold the entire December salary and the December Christmas bonus. For the non-payment of December salary, claimant tendered his offer letter, his confirmation letter, and even Exhibit C7 paragraph 9. There was a demand for it. The defendant argued that claimant failed to show it was illegal or malicious, that he was not paid his December salary. Besides, claimant had no knowledge of others who were not paid and never demanded for it. By Section 7 sub C of the National Industrial Court Act, it states, and I quote, "The court shall, in exercising its jurisdiction or any of the powers conferred upon it by this act or any other enactment or law, have due regard to good or international best practice in labor or industrial relations, and what amounts to good or international best practice in labor or industrial relations shall be a question of fact." End of quotation. The provision of this section empowers the court to suo motu have due regards to good or international best practice in labor or industrial relations, given that some of these practices have been canonized as conventions, and the court, being a court of law, is empowered to interpret laws. Be that as it may, Section 7 sub C of the National Industrial Court Act equally states that, and I quote, "What amounts to good or international best practice in labor or industrial relations shall be a question of fact." This then requires parties seeking to invoke the court's jurisdiction on matters of good or industrial best practice in labor or industrial relations to plead certain facts in that regard. The claimant, having exhibited Exhibits C3 and C6, demonstrated that contrary to contract of employment, his December 2021 salary was not paid. It therefore behoved on the defendant to show the rationale behind the non-payment, which in this court's perspective view, it did not. On this note, this court has no difficulty finding that the refusal to pay half September, October, November, and the full December salary by the defendant violates ILO Convention 95 and the Labour Act, I so hold. As for the Christmas bonus, this court has no evidence before it to prove that it was a term in the offer of employment, Exhibit C1 and 2. This court therefore declines to declare that the refusal to pay is illegal, unlawful, amounts to unfair labor practice, and contrary to international best practices in labor, employment, and industrial relation matters. In view of the above reason, this court is hereby declares that the refusal of the defendant to pay the claimant the outstanding balance of the claimant's half salary from the month of September, October, and November, and the continued refusal of the defendant to pay the claimant his December salary is illegal, unlawful, amounts to unfair labor practice, and contrary to international best practices in labor, employment, and industrial relation matters. Relief 1 succeeds and Relief 2 succeeds in part. For the pleading and evidence led, it is left for the defendant to justify the reasons for paying half salary and not paying the entire December salary, and must therefore tender any document he needs to justify them. The defendant failed to justify both the half payment and the non-payment, while the claimant successfully proved this aspect of his case. Having held that the claimant proved his case, it follows axiomatically that he must be entitled to some reliefs. Let me now examine the reliefs claim to see which the claimant is entitled to. The second issue for determination is if the answer to the above is in the affirmative, whether the claimant has proved his entitlement to all or some of the relief sought against the defendant. The resolution of this issue is a function of the answer to issue 1 and 2. This court has answered issue 1 and 2 in part in the positive. Therefore, it becomes necessary to consider the reliefs. The determination of issue 1 and 3, the affirmative, partly is the pillar upon which the entire case of the claimant rests. Issue 1 having therefore been decided against the defendant, relief C, D, E, and F succeeds, while relief G fails accordingly. The relief H is a claim for 2 months' salary in lieu of notice. By Exhibit C1, it provides thus, and I quote, during this period, a minimum number of 2 months will apply after your employment is confirmed, end of quotation. By Exhibit C2, the claimant was a confirmed staff, therefore entitled to 2 months' notice of payment in lieu of notice. Claimant led evidence to show that his last day at work was on the 7th of January 2022. Parties are in agreement that no letter of termination was issued. Neither was he told verbally not to come to work. Claimant pleaded that he could not afford his transport fare to work because he was being paid half salary from September to November and no salary at all in December. Therefore, he stopped going to work. Is this court convinced that claimant is entitled to 2 months' salary in lieu of notice in the sum of 414,761 naira 88 kobo? I don't think so. Claimant was at work on the 5th of January, which was his last day of work, and sent the letters for demand on the 7th of January 2022. In the circumstance, the contract of employment has been determined irretrievably. I make no order as to the payment of 2 months' salary in lieu of notice. I so hold. Relief I is for refund of stabilization fund. By Exhibit C1, the sum agreed on is 225,000 naira per annum and payment yearly after anniversary of your employment from the company, end of quotation. The parties are in agreement that stabilization fund was a policy of the defendant company and provided for in Exhibit C1. By Exhibit C3 and C6, there is no evidence to show that it was ever paid for in the month of September 2021, which was the due date for payment. During cross-examination, claimant testified that in the offer letter, it was a voluntary deduction made at source. This court is convinced that this sum was deducted and must be refunded to the claimant. I so find. Relief 1 succeeds. I so hold. Relief J is for an order compelling the defendant to pay the claimant the sum of 100,800 naira only, being the claimant's leave allowance for the year 2022 and 2021 respectively. By Exhibit C1, the offer of employment there is by Exhibit C1, the offer of employment, there is a provision for annual vacation, and I quote, you will be entitled to annual vacation of 20 calendar days effective on your successful completion of 1 year of service with the company. Your leave bonus is 12% of your annual leave salary. In paragraph 12 of the written statement on oath, claimant led evidence that it was not paid for 2020 and 2021. By Section 18 of the Labour Act, it provides for holiday with full pay of at least 6 working days. Exhibit C1 was provided. Exhibit C1 has provided for annual vacation and pay. The defendant has not led any evidence to adduce the fact that it paid annual leave allowance for 2020 and 2021. The claimant succeeds in his relief J. I so hold. In relief K, claimant is seeking for an order compelling the defendant to remit the claimant's pension in the sum of 170,600 naira only for the year 2022 and 2021 to the claimant's pension manager. The right to pension is statutory and must be provided for in every contract of employment. Further to the above finding of this court, it is the duty of the employer to deduct and remit pensions together with the contribution of the employee. This is a statutory obligation which carries a penalty for failure to comply. By Section 11 sub 3 of the Pension Reform Act 2014, it places a duty on an employer to deduct at source the monthly contribution of the employee and within 7 days of such deduction remit the amount to the pension fund custodian mentioned by the PFA. Section 4 provides guidelines for such contribution, and Section 103 states that the person who does not comply with the provisions of the law has committed an offense. Section 100 sub 2 compels the defaulting employer to refund all monies not remitted or misappropriated. In the case of Momudu versus Nemex International Pharmaceuticals Limit PLC, citations provided, it was decided that where such remittance is not done, the total unpaid contribution shall be recoverable as a debt. It is in evidence before this court as shown that the total pension contribution of the claimant is 170,600 naira. The defendant did not rebut this claim or that pension contribution was remitted as at when due in compliance with Section 11 sub 3 of the Pension Reform Act of 2014. This amount has become a debt owed by the defendant to the claimant. The law as stated in the above cited cases is that the sum must be recoverable from the defendant as a debt. In this wise, this court hereby orders the defendant to pay the said sum of 170,600 naira to the claimant as his pension contribution. Relief care succeeds, I so hold. Relief L&M are for an order awarding the sum of 5 million naira as general damages for illegal and unlawful refusal to pay the claimant's entitlement and 20 million naira against the defendant as exemplary damages for the illegal and unlawful refusal of the defendant to pay the claimant his entitlement. In Cabo F versus Mohammed, citations are provided. The principles guiding award of punitive or exemplary damages was explained per Abiru Jessier as it then was. Thus, punitive or exemplary damages are intended to punish and deter blame, worthy conduct, and thereby prevent the occurrence of the same act in the future. They are awarded whenever the conduct of the defendant is sufficiently outrageous to merit punishment, as where, for instance, it discloses malice, fraud, cruelty, insolence, or flagrant disregard of the law. In the instant case, the actions of the appellant were selfish, self-centered, callous, and downright wicked. The respondent predicated his course of action in thought and not in contract, and the actions of the appellant amounted to a conduct deserving of punishment by the award of punitive damages. End of quotation. University of Calabar versus Soji, Zenith Bank versus Keruwem, Udo versus Kitipopa, citations all provided. The defendant in this case withheld half of claimant's salary for 3 months and did not pay salary for the 4th month, which was in December, in spite of the festive season. The defendant failed to remit pension or pay leave allowance and refund the stabilization fund, even when claimant in his letter explained the dire accommodation crisis he was facing at the time. This court is convinced that the claimant is entitled to both general and exemplary damages in the sum of 500,000 naira only. I so hold. Relief N is a claim for interest on the judgment sum at the rate of 20% before judgment and 15% post-judgment until the judgment sum is liquidated. The general rule at common law is that pre-judgment interest is not payable on a debt or loan in the absence of express agreement or some cause of dealing or custom to that effect. Thus, pre-judgment interest will be payable where there is an express agreement to that effect, and such agreement may be inferred from a cause of dealing between the parties, or where an obligation to pay interest arises from the common practice or usage of a particular trade or business. See Alfontrin Limited versus Attorney General of the Federation, Diamond Bank Limited versus Partnership Investment Company Limited, citations all provided. Consequently, a plaintiff, in order to succeed in a claim for pre-judgment interest, must show how the entitlement to such interest arose. That is whether by law, by contract or agreement, or by just pleading facts showing that the claim is part of the loss or special damages which the defendant wrong imposed on him. It is not enough to merely say that the plaintiff is claiming interest. The basis of the claim of interest must be made manifest on the pleadings. Ekunife versus Wayne, Sani Abacha Foundation for Peace and Unity versus UBA, citations all provided. In the light of the foregoing authorities, it is without doubt that the claimant presented no scintilla of proof that there is either an agreement for 20% interest or statutory provision imposing the payment of the said interest on the sum awarded to the claimant as prejudgment interest. Consequently, the claimant is not entitled to prejudgment interest and same is accordingly refused. With regard to post-judgment interest, on the other hand, I take into cognizance the provision of the rules of this court, which is by Order 47, Rule 4, stipulates that the court may, at the time of delivering judgment or making the order, give direction as to the period within which payment is to be made and may order interest at a rate not less than 10% per annum. The claimant is also seeking relief or a perpetual injunction restraining the defendant or any of its officers from constituting any disciplinary panel from going ahead to determine the claimant's case. This relief has been overtaken by events and is thereby dismissed. As for costs of this action, parties are to bear their respective costs. The orders made on compliance and sums of money awarded and due in this judgment shall be complied with, and payment made to the claimant by the defendant within 30 days of this judgment, failing which it attracts 10% interest per annum until fully liquidated. Judgment is entered accordingly. Signed. So this is the
As the court
judgment of the
pleases.
court.
My Lord, we are indeed very grateful for the well-considered judgment of the court. We appreciate your lordship.
Okay. You're welcome.